Okay, and welcome to my Friday tip. And this time we are going to be looking at a little bit of the legislation, and that's because I've been on holiday. And whilst I was away on holiday, getting a tan in Turkey, I wasn't able to really prepare anything else. And when I got back, I asked around the office, and people are still continuing to talk about GDPR, specifically in relation to B2B and email marketing. And to a degree, there's a bit of confusion still. So what I was going to do is I was going to very briefly go through what the legislation is, what you can do, and what you can't do, and how Pecha changes things as well, Pecha being the Privacy Electronic Communications Regulation. About 10 minutes, not too long, and it will give you a pretty clear overview of what you can do. Okay, I'm actually going to be reading from a blog post on the ICO's website. So this is not a fabrication from a dream or some other kind of different dimension. This is from the ICO's website themselves, and I will put the link in the post just below in the comments or the description, so you can go along and check it out yourself. The good news is that you can send emails to businesses using what we refer to as legitimate interest in most circumstances, or in some circumstances. However, the GDPR does apply to business data. So if anybody's told you it doesn't, and your business data includes information that is personally identifiable, like an email address with a first name and a last name, then it does apply. But that doesn't mean that you can't send to it. It simply means that GDPR applies. So you have to follow the rules, and I'm going to go through those in a little bit of detail now. Okay, so first question, does the GDPR apply to business marketing? Yes, the GDPR applies wherever you are processing personal data. This means if you can identify an individual, either directly or indirectly, GDPR will apply, even if they are acting in a professional capacity, so business email address. So for example, if you have the name and number of a business contact on file, or their email address identifies them, such as duncan.gledhill@emailmovers.com, the GDPR will apply, because you can identify that you can identify a person. Okay, the GDPR only, I don't know why this bit's in here, but anyway, I'll cover it off. The GDPR only applies to loose business cards if you intend to file them or input the details into a computer system. So, yes, business cards are covered, but not if they're loose, flying around the office after a show, only if you input them into a system. So does the GDPR mean we need consent for marketing? What a great, the ICO cut through a lot of clutter here, and they went straight for the jugular. Does the GDPR mean we need consent for marketing? When I say we, I mean businesses, whether or not you're a prospect or a customer of ours. That's the we. Not always. Consent is one lawful basis for processing, but there are alternatives. In particular, you may be able to rely on legitimate interests to justify some of your business-to-business marketing. However, sometimes you will need consent to comply with the Privacy and Electronic Communications Regulations, which I spoke about a moment ago. And there is a whole entire different guide on that, but it's covered off here anyway, so we'll jump onto that. So when can we rely on legitimate interest for marketing? You can rely on legitimate interests for marketing activities if you can show the way you use people's data is proportionate, has a minimal privacy impact, and people would not be surprised or likely to object to what you are doing, but only if you don't need consent under Pecha. So I ran a survey using Google Surveys about a year and a half ago, and the question was all around whether or not you'd be surprised at work to get an email from somebody relating to your job title there in your place of work who you've never heard from before. And the vast majority of people said no, they wouldn't be surprised. So if you are the purchasing manager, or let's say the finance director within an organization, and you get an email from a company that is selling you an online account system, would you be surprised that you've got that email? No. That was the survey response. The survey said no. Which is obvious. I mean, if you've got a job and your job role is something quite specific, then obviously you're not going to be surprised when you get emails about your job role from companies that are trying to give you products or services that may help you. So that was quite an interesting survey. However, does Pecha still apply? So this is quite interesting. So we know that GDPR does apply. However, we do know from this ICO post that we can use legitimate interests. So what about Pecha? It's been mentioned a couple of times. So yes, GDPR does not replace Pecha. Although it has amended the definition of consent, you need to comply with both GDPR and Pecha for your business-to-business marketing. So don't forget, Pecha was all about electronic communications. The EU is in the process of replacing the current e-privacy law with a new e-privacy regulation. However, the new EPR is yet to be agreed. The existing Pecha rules therefore continue to apply. So what are the rules on marketing emails or texts? So I'm going to be really looking at just emails for obvious reasons. So sole traders, this is where it becomes really interesting. Okay, we're at 7 minutes and roughly 7 minutes into the video here. So if you're just joining us, then this is what we're talking about in terms of email marketing and Pecha, and what you can and cannot do. Sole traders and some partnerships are treated as individuals, so you can only email or text them if they have specifically consented, or if they bought a similar product from you in the past and didn't opt out from marketing messages when you gave them that chance. You must include an opt-out or unsubscribe option in the message. The first part of that paragraph is key. Sole traders and some partnerships. Don't forget, we're only talking about businesses here. Sole traders and some partnerships are considered to be individual subscribers. They're not considered to be corporate or PLCs. You can email or text any corporate body. This is where it gets really interesting for the B2B marketers out there that are chasing after or prospecting to limited companies and PLCs. And we are 8 minutes, roughly 8.5 minutes into this. So you can email or text any corporate body, a company's Scottish partnership, limited liability partnership, or government body. However, it is good practice and good business sense to keep a do not email or text list of any business that object or opt out, and screen any new marketing lists against that. So, black and white, you can email or text any corporate body. You may also need to consider the GDPR if you are emailing employees at a corporate body who have personal corporate email addresses, i.e. first name dot last name at, and then the organization's domain. So this is really, really interesting, and it's really important, that last bit. So where we're told you can email or text any corporate body. However, if there is a first name and last name, you need to consider GDPR. So what impact would GDPR have on that? Obviously, you need to protect that data. And you need to make sure that when you are working towards protecting that data, that if anything goes wrong or if anything goes right, you need to make those people aware and so on, all of the other GDPR regulations that come in. So if you've got a list that you bought or that you've created or that however you've come across it. And that list is saved on a PC. To be absolutely honest, you should make sure that the list is password protected, and where possible, use a password password management application so that the password is a nice strong one, and make sure that the people who have access to that password and to that file are restricted. And when you are using it, make sure that you do some kind of a risk assessment on it. So if you're using a new application, where's that information, where's that application hosted? Is it in the UK or is it in the US? And all that kind of stuff, which is basic GDPR stuff, protecting that data. But it doesn't stop you from emailing it. And that is the point of this, this little video here. So I'm going to put the link to that video, I'm going to put the link to that document in the description or the comments below. I do welcome any questions. I am not the ICO, obviously, but I am able to give you a little bit of guidance if you are talking about business-to-business email marketing, and specifically I can show you a little bit more detail on how this blog post can make sense to you. With that, thank you very much. Please, if you found this video relevant and valuable, do subscribe. I do a video every Friday morning when I'm not on holiday, and it's nearly always about email marketing, nearly always focused on B2B, and it's nearly always focused on trying to improve the results, trying to improve engagement. And they're quite quick tips, about 10-15 minute videos on YouTube, shorter bite-sized videos on LinkedIn, and of course there's a little bit there on Twitter as well. So until next Friday, thank you very much for joining me, and have a wonderful weekend.